Your Honor, Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard.
For the record, Your Honor, my name is Terrence Ginyard.
And Your Honor,
He's waiving.
he is waiving. I do have an offer to place on the record as it stands. That offer is that he waived for the purposes of pleading to one count of the firearms possession by a prohibited person. Count 2 and count 3 would be dismissed. It would also be a plea to count 4, the misdemeanor receiving and concealing 200 or more. That would come with a forfeiture of the weapon, restitution, if any, standard conditions upon that waiver. That's people's understanding.
All right. Mr. Ginyard, you're waiving your right to a preliminary examination, sir?
Yes, sir, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do, Your Honor.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, we would acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all counts, court will enter a not guilty plea. Pretrial will be set for
January 27th at 1:30 before Judge Simpson.
January 27, 2025, 1:30 before Judge Simpson.
Your Honor,
Yes,
if we may address bond at this time.
briefly.
Your Honor, my clients, I think the court has the information from last time with regard to the blood results that he was able to take. At this time, I am still asking for his release. He's willing to do tether at whatever conditions that the court deems necessary to. He received a 7-day notice to quit, eviction notice that starts today. He has also got a kid who is autistic, whose birthday is today. He lost his job, unfortunately, as a result of this case, understandably so. He's going to need to move out of that location, as the court knows, for purposes of securing new housing for his family, his children especially. I would just ask for a plea for his release at this time on PR.
Any response from the people?
No, Your Honor.
Well, why are you drinking?
Sir.
Go ahead.
So I got the blood test on the 2nd to show that I wasn't drinking. I wasn't drinking, Your Honor, on the 22nd. I didn't have any alcohol. That's why I went on my way to pay for a blood test. And the blood test, the levels was 1.0 and it said 1.4 is 0 to low alcohol.
Yeah, but
Yes, sir.
I remember going through all of that last time, and I'm telling you that test doesn't tell me much.
We understand that, Your Honor.
Because I've got repeated tests where on the 22nd and the 27th, you're testing positive, you're drinking.
The one time I did say that I was drinking in November, Your Honor, I did admit to that. I definitely did. And you said we'll put it for
Put it over.
we'll adjourn it or whatever. And then we just got to this adjournment with what I proved that I wasn't drinking. And
No, you didn't.
sir.
Oh, hold on.
Okay.
You didn't. That's not what that test shows me.
So CMH has given me what I wanted to tell you, a shot.
The Vivitrol.
Yes, and that's like an alcohol blocker. And they said if I drink on that, bad things can happen to me.
Where is that?
That's what CMH, sir.
Your Honor, I don't have receipt.
I don't have that before me. You're telling me
That's what I'm going to be put on. I'm already taking.
so you're not put on it right now.
No, sir.
Your Honor, I would ask for consideration for random drops at this point, if the court would be willing to consider that. I think that would, I think testing in front of someone at this point may be helpful in terms of monitoring the situation versus the scram tether or sober link. I would ask for consideration for that. I do know that my client has a desperate need to leave the jail.
I understand that, but I also understand what he's done to get himself there, because he wasn't there to start with. And now you're asking me to change it, and I haven't been shown anything. really, that's convinced this court that those episodes didn't occur. And he's not on a medication that's gonna stop him from drinking.
For your mama.
Hey, dude, I'm on.
Seriously. So this is, I mean, nothing's changed from the last time that I denied it. And so he'll be up for Judge County. Maybe she'll feel differently than that, but at
I'll
this
do
point,
anything to any type of drops though, Your Honor. They do want to put me on the thing today as far as the Vivitrol. They told me tonight I can get a shot, but it's also if I'm going to be
you're
here.
telling me that, but I don't have anything that indicates that. I have nothing in writing saying that's what's gonna happen.
I just was trying to move, man. I know I have to move, but I have a 7-day eviction. Since I've been in here, I don't really know what to do. I have autistic son. I have a lot at
Mr.
home.
Ginyard, I understand and I can appreciate the circumstances that
No
you're in.
scram tether or anything I can do, sir, for you? Anything, just for a week, just to show till I come back to court?
I'm not changing my position. I've said what I've said.
Mr. Benson, will you state your name for the record?
Bershon Vincent.
Your Honor, the court should be in receipt of the plea information.
I have a plea form that indicates that I'm pleading no contest to 2 charges of attempted resisting and obstructing a police officer, both 1-year offenses. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes.
May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so you got?
Yes.
Lower your hand, state and spell your name.
Bershon Vincent. Bershon.
All right, you're gonna have to speak up a little bit, okay?
Bershon, Bershon.
All right. Sir, it is this court's understanding that you're gonna plead no contest to 2 charges of attempted resisting and obstructing a police officer. Those are misdemeanors, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these 2 charges. You understand that?
Correct.
All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Bravo or her successor in the 15th District Court. Do you understand that?
Correct. Correct.
Okay. Still wish to plead no contest?
Yes.
To the charge of attempted resisting and obstructing a police officer, how do you plead? As contained in, to that same charge as contained in count 4, how do you? Now, you understand that by pleading no contest, you'll not have a trial of any kind. You had signed on your behalf an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
The rights, no.
No? Right down below you on the podium. Copy of 1. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Correct.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes.
and of your own free will.
Correct.
Court has been provided and has reviewed 2 police reports from the Ann Arbor Police Department. And one being their case number 24-44505. And also 24-44468. Any objection to the court having reviewed those reports?
No, Your Honor.
No. Sir, based upon a review of those reports, the court does find that there's sufficient basis in which the court could determine the defendant's guilt of these offenses. Sir, if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
I'm sorry,
Yes, sir.
you understand? Okay. Counsel, are you aware of any other promises, threats, or other inducements which have led to these pleas?
No.
No, Your Honor.
And have I complied with the court?
Defense is satisfied.
Yes.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 3rd, 2026, 9 a.m. For Balbo. Bond will continue.
Your Honor, may I briefly address
You
bond?
may.
Your Honor, Mr. Vincent is asking the court to consider a 10% option. I know that he previously failed to appear. I believe the bond is set at $25,000 cash or surety. He's asking for that 10% option. He informs me that he is now employed. His life is in a better position than it previously was when he had failed to appear back in July. He's working at Vertical Construction, and he also at this time has accepted responsibility and has entered a plea, as the court's aware, set for sentencing in the 15th, and he understands if he were to violate his bond and not appear for that, there would be repercussions that he would have to face with the court.
Okay, I get that, but here's what the problem is. Back. And I really don't know whether to trust him that he'll appear or not, because on August 28th, 2025, he didn't appear before the court. Court issued a bench warrant. We recalled that, or somehow or another, you came into custody. I think we recalled it. And set another date for you, which was in October. Now, what you were doing between then and then, I'm not. Man, we set a date in October for you to come back. You don't show up.
Yes, sir. You can definitely trust me. I did talk to the attorney on that day.
On which day?
On the last court date that I missed, and I was supposed to be on Zoom, but I had a miscommunication about the time.
Okay, I hear you.
I logged in late.
Pardon?
I logged in late. I did talk to her and told her I was going to accept the plea on that day. I just logged in late that day, and I wasn't let into the courtroom.
Okay, so that was in October, or in, October. So what brought you back into custody?
Your Honor, he had contact with the police, I believe, in Farmington.
Auburn. He was
Auburn.
pulled over because of window tint.
But, okay, get my point on this. I already had 2, and then you don't come back in. You say you signed in late. I get that, but then you don't come back in. You have to be stopped by the police and then brought to us.
Yes,
That's a problem.
I understand that, sir, and take full responsibility.
And so in that respect, I can't say that you'll appear. Maybe after dealing with the 15th District Court probation, they can make a recommendation to the sentencing judge and they'll release you, but I'm not going to give.
Can I just ask one question regarding court rules?
Court rules?
Yeah,
Sure.
Court rules. I read that, during a court proceeding error, that it was supposed to benefit the litigant.
During what?
During a court proceeding, I believe there was an error during my arraignment. That,
In your arraignment?
Yeah, during my arraignment, my bond was originally set at 25,000, 10%, but the judge who arraigned me changed it to 25,000 cash or surety, saying that it was a mistake made, and that was his basis.
At which arraignment?
I think he's talking about the arraignment that he just came back in on the bond or the failure to appear warrant.
That it was set at, say again?
Yeah, I was prepared to make 10% bond, but it was changed at my arraignment to 25,000 cash assured. He said that.
No, that's not what it was changed to. That is what I ordered when you failed to appear for the second time.
Okay, I apologize, but the court entered it in the computer wrong, and it was.
I don't know what happens in terms of entering it in. All I can tell you is that when I issued the bench warrant on October 9th, it was $25,000 cash surety. And so when you came through that arraignment, when you finally showed up sometime this year or whatever you showed up, then the magistrate held that bond that I had set on your warrant. So there was no error in terms of what the people in the court did. I don't know if there was a paperwork error. I don't see
Yeah,
it.
it was paperwork.
All right, thank you.
Thank you.
Okay, well.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shelley. Mr. Shelley, will you state your name for the record?
Tim Frank Shelley.
Your Honor, we are here today on a bond violation as well as the PCC. Mr. Shelley is asking that his case be set for preliminary examination, and he would admit to the violation. He would ask for time served on that.
The discovery is complete. Would the people have their witnesses available to 27?
Yes.
Preliminary examination in person. Set January 27, 2026, 9 a.m. When did he come into custody?
I've got about 22 days.
No, but this last,
Oh,
Judge, I can check real quick. I think it was just a few days ago. On this most recent. On the 11th, Judge, so 4 days.
all right. Here's what I'm gonna do. On his bond violation, I'm gonna sentence him to 15 days. Washington County Jail. Well, I don't want to do it that way. I'm gonna do actually 20 days, Washington County Jail. Credit for balance to be served. And one can address an altering of that sentence at the prelim. That's on January 27, 2026, 9 a.m. before Judge Washington. But the intent of the court is that he stay in until the pre.
Understood. Thank you.
Thank you.